Greetings across the earth. Greetings across the earth. I don't know how the volume is with the outdoors. I mean, I look on the Wi-Fi signal and it kind of look a bit shaky, but we are putting in the work. Me have at the headline, it said Guaranty as affected by statutes of fraud. Now, this information I got kind of go over my people head. But again, me have to bring it forward because we don't have nobody to share this kind of information on this island or in the Caribbean so-called area or West Indies area. We don't have nobody to share this kind of information. And it's only because I'm in this situation. Yeah, man. So I have to function from first-hand knowledge and I have to share I own personal first-hand experience. Now, I'm on go court Friday over Spanish Town. And I intentionally went there late. Because every time I go to them have a big man like me, I wait all day like me or some little schoolboy or something, and I don't appreciate that. Right now, my head lift. I'm tired of these sodomite governmental agencies and them people. I'm kind of sick of it right now. So, I just go lit my fire according to I. And today I did intend to come out here with straight savage language and tell them about them mama and up under them mama. Some me did intend for go on, but I man spirit say watch ya. Just go and balance and just share the information. Now I man say I writ by affidavit, guarantee as affected by statutes of fraud. Jamaica Judicator, Court Administrative Division. Do not trespass. Termination of liability to notice of recognizance. Spanish Town Code 2023, Traffic Code 100506, and I guess 4 counts 1, 2, 3, 4. Now we said Judge Miss K. Lumi, according to how them give me the information. Them not give me a first name. First name was withheld. Court Clerk Mr. D. Kelly, first name was withheld. Senior Sergeant of Police, Mr. A. Edwards, first name was withheld. Constable, Mr. Andel Morgan, number 17034. Pursuant to police witness statement issued on the 3rd of March 2023 as cause for their action. Now it's a collateral security. We are talking about the birth registration form. Oh, a little clown up on a dirt bike. Me I tell you, sir, you know, well, they might have fun. Me not gonna say nothing about that. We talk about collateral security. The collateral security of the birth registration form, that bond paper, we want to call birth certificate. That's the collateral security. Now we say guarantee and surety terms define and distinguish pursuant to the negotiable instrument law. Yeah, me no mind I repeat myself, me no mind I repeat stuff, because again, as I said, there is power in repetition. Yeah, man, there is power in repetition. I hope I make that thing a private indirectly. However, me just go and push the information so it get out there. Guarantee contract. I'm the guarantor, Linton-O'Neill, $Dallas. That's me, guarantor. Number one, them say guarantee is an undertaking by one person that another shall perform a contract or fulfill his obligations. And in case he does not do so, the guarantor promises to answer in damage. A guarantor of a bill or note is one who engages that the note shall be paid. Guarantee is an undertaking to answer for the debt or default of another within the meaning of the statute of fraud, and must accordingly be in writing and signed by the party to be bound or his lawful agent. So the guarantee contract is what was signed, but them not disclose that instrument to it. I remember signing that document. I think I have an image of the face of that document. But them never issue it like how them issue the notice of recognizant promissory note. Number 3 says the statutes provide that no action shall be brought to charge any person upon any special promise to answer for the debt, default, or miscarriage of another, unless the promise, contract, or agreement upon which such action can be brought, or some memorandum or note thereof, shall be in writing and signed by the party to be charged therewith, or by some person thereunto by him lawfully authorized, by any lawful, well, again, by a person who is lawfully authorized. And the consideration of any such promise, contract, or agreement needs not be set forth in writing, but must be proved. Again, them says the consideration of any such promise, contract, or agreement need not be set forth in writing, but may be proved. Number 4, in order that the agreement may be controlled by the statute, it must contain a promise to answer for the debt of another, both in form and in fact. Number 5, it has been held that if the transaction be nothing more than an indirect way of guaranteeing the payment of one's transfer of his credit, such as giving the note to another, which is payable to himself with a guarantee that this third person's note will be paid. The guarantee is substantially that the guarantor's original debt will be paid by the collection of this third person's note, and for this reason, the guarantee need not be in writing. I hope my people I get it, Now we say surety contract. Within the grantor contract, there is a grantor. Seeing? And we sign that document as such. The grantor will secure the solvency of the debt. So this is like the private credit side. I'm tell you, so them get all the source. I as man is the source of whatever commercial agreement that is out there. I am that source. I am the energy. But them won't tell you these things. Again, and the creditor is not required to proceed first against the principal before he can recover from the surety. Let me start with number 1 again, suretyship contract. A contract of suretyship is a contract by which the surety becomes bound as the principal or the original debtor is bound. This is what me I do, man. I kind of I move away from number 5. Me there number 5 and just number that, and that, chop it up a little bit. Let me go back on number 5 before I go down to the surety. Again, it has been held that a transaction, that if the transaction be nothing more than an indirect way of guaranteeing the payment of one's transfer to his creditor, such as giving the note to another which is payable to himself, with a guarantee that this third person's note will be paid. The guarantee is substantial that the guarantor's original debt will be by the collection of this third person's note, and for this reason the guarantee need not be in writing. However, them thing I have to go in a writing once it's contract. I have to go in writing. And we'll go back to the surety contract now. Now we say with the surety contract you have a principal and the surety. And with this thing, I am the principal, Linton O'Neill Dallas, Linton hyphen O'Neill, full colon Dallas, principal. The surety is the all capital birth certificate. You understand? And according to how them contract and how them system is, them say boy, they are joined together. So let me read. Number 1, a contract of surety. Let the rider ride out there. A contract of suretyship is a contract by which the surety becomes bound as the principal or the original debtor is bound. We discussed this already. It is a primary obligation. It is a primary obligation. And the creditor is not required to proceed first against the principal before he can recover from the surety. And remember the surety at the bank. You understand? But the bank can't talk for itself, so you have to do all of the talking for it. The surety is bound with the principal as an original promisor. That is, he is a debtor from the beginning and must see that the debt is paid and is held ordinarily to know every default of his principal and cannot protect himself by the mere indulgence of the creditor, nor by want of notice of the default of the principal. However, such indulgence or want of notice may, in fact, injure him. Being bound with the principal, his obligation to pay is equally absolute. Number 3, one who sign a promissory note on the face thereof and who is in that way becomes a surety of the principal maker is under negotiable instrument law primarily liable for the payment of such note. On the other hand, the contract of the guarantor is its own separate contract, 2 different contracts in play. It is in the nature of a warranty by him that the thing guaranteed to be done by the principal shall be done, and it is not merely an engagement jointly with the principal to do the thing. A guarantor, number 5, a guarantor not being a joint contractor with his principal is not bound to do what the principal contracted to do, like a surety, but only to answer for the consequence of the default of the principal, if there is any default. And we touched upon these things already where we say intent. Negotiable instrument law provides a person placing his signature or his mark on an instrument otherwise than as marker, drawer, or acceptor is deemed to be an endorser unless he clearly indicate by appropriate words his intention to be bound in some other capacity. And again, we touched upon that already. Some differences between the grantor and the surety, we touched upon those things already. This is where we touch upon, but I kind of extend this a little bit more. We said discharge of grantors and sureties. Grantors and sureties may be discharged in any one of the following ways: by a discharge of the principal, as anything which discharges the principal will discharge the guarantor or surety; by the signature or assent; by the signature having been obtained by fraud, yes; by the surrender of the principal or other party to the paper of the collateral securities, that's the bond paper; by the misrepresentation, this is what we never touched on before, number 4, by the misrepresentation or concealment to induce his becoming surety. Remember, I tell us that them kidnap we, and by giving us the notice of recognizance under threat, duress, and coercion when they're armed. You understand? So that alone nullify the document. Now, them I say the contract is voidable. Number 4, the contract is voidable from the beginning as between the surety and all parties privy to such misrepresentation or concealment. If a principal sign under duress, the holder guilty of the duress could not enforce the obligation against the surety. This is why I now go back a court. You understand? Because I'm sure me and them people have no contract. I'm going to prove it so we don't have no contract. The only contract where we can talk about, what can be verified, is the do not trespass notice that these 2 police officers violate. And the do not trespass notice that is on the traffic court record that even the judge and the court clerk choose to violate. So these are contractual breach that will be obvious. You understand? And their antecedent contract, they can never present that where my signature is. Yeah, man. So again, they must say once, if a principal sign under duress, the holder guilty of the duress could not enforce the obligation against the surety. So the moment I sign the notice of recognizance under threat, duress, and me express it, then it's void. This is why I'm going to terminate that piece of document easily. And as such, the guarantorship is terminated too. Number 5, by the diversion of the instrument from its agreed purpose. This is where them at, I said we commit a crime when traffic infraction a misdemeanor. Where is the crime in the traffic infraction? You understand? Yeah. By the diversion of the instrument from its agreed purpose, as where accommodation papers is signed that it shall be used for a particular purpose, and diversion in its use operate a discharge of the accommodation party as to all other parties who have knowledge of such diversion. All of them are conspirators. All of them know about it. Number 6, alteration. Any material variation in the instrument without the consent of the surety will discharge him. So, on a sister, these people can't do nothing without our consent. Where them administrate, them no need for administrate, because I'm an executor over my estate, and no sodomite can underwrite my bond. He will be committing fraud openly. Yeah, man, wanna run risk, wanna for pay the price. Yeah, man. Number 7, payment. Thus, payment by the parties primarily liable discharges parties secondarily liable, as payment by the maker or acceptor discharges the drawer and the endorser, and a tender of payment which the holder refused to accept discharges the surety. So when Digicel refused to accept my tender of payment, it literally discharged my surety. That's why I know I can bring a claim against that company, and I shall. But everything I go accordingly, step by step, step by step. Now we say release. Number 8. A release of the acceptor or maker discharges the drawer and endorser. Number 9. Satisfaction. The holder's claim may be extinguished as to an endorser or end drawer, and the debt not be satisfied. But if there is a satisfaction by one, it operates as to all. Number 10, covenant not to sue a prior party. We're not sure about that, but that probably not a covenant, but we don't know about, because we don't get to see the document. This discharges the surety because it disables him from suing should he pay the debt. Number 11, parting with security for the debt. It should be collateral security for the debt. Thus, if any collateral security with the creditor held be released, or a judgment lien given up, or a levy withdrawn, the surety is discharged. So yes, when I'm going there with my document, because I always carry my surety with me, to stand in my place and protect me. You understand? Parting with security for the debt. Thus, if any collateral security which the creditor held be released, so I not forgot release my collateral security. You understand? You don't have to go release. You don't have to go release my collateral security to me. Yeah, man. Number 12, agreement. To indulge prior party by extension of time or forbearance of suit. It is held by the weight of authority that a plea of fraud or misrepresentation will not avail to discharge the guarantor or surety against a bona fide holder. Now we not plea. When we are make our writ, we are said this is what these people have done. You understand? And if them cannot rebut it, then it stands as truth. Number 13, the surety or guarantor is discharged if the holder surrenders the collateral security to the principal or any other party to the paper. If the holder enters into a binding contract for the extension of time, they are discharged. Again, they are discharged. So when we got quote on them people, you talk about put it off, boom. From you have this information called this negotiable instrument law. It is discharged, my people. Number 14, under the principles of subrogation, the guarantor or surety has a vested interest in the collateral security which cannot be jeopardized or destroyed without his discharge from his liability. These people are playing games with us, my people, because we don't really have the information when necessary. Number 15, the agreement for an extension of time. For an extension of the time of the payment in order to be discharged must not only be based upon a valuable executed consideration of some sort, but the agreement must be absolute and for an extension of payment for a defined period of time. So what may I try say when may I present them information here is to demonstrate the fact that there is absolutely no reason for this. Yeah, that's a statutory agency and it's public service authority agents to unlawfully interfere with my liberty by kidnapping me, falsely arrest me, falsely imprison me, and then under threat, duress, and coercion, issue me a notice of recognizance bond, which is an access device trying to access my birth trust, where them cannot access without my consent. So this is why me I put a stop to it, and later me I go send a letter directly to them FIDI commissary, which is Fidelity up there in Massachusetts Business Trust, directly, only because me have the information. And so when I do that, what I gotta do is jam up the court clerk called Dave Kelly if him not choose to withdraw this mess where I try, this fraud where I perpetuate. This is why I say it's a sophisticated slavery, and I won't be enslaved by these unlearned public authority agents, these public servants. I say fire burn to on the core. I now come back on the court more than when I come here, I come place some documents in our office where I go direct on to a violation of the do not trespass notice. So you see when I don't want enforce on a fictitious warrant, I go again trespass against I estate. That's what we're going to do. And we're going to naturally stand our ground and we're going to naturally defend our right, preserve our hereditament, and we're going to secure our estate. You people administer our estate because you know, say we lost at sea and it's abandoned, and me I say it's not so. It's not so. Now, I say conclusion. There is no valid contract in dispute, only unverifiable or unvalidated claim, which are in fact presumptions being made by the state agents. Number one, the original promisor or debtor is bound only upon verified proof of an antecedent or pre-existing contract signed by the original promisor or debtor to validate such claim or presumption. Number two, without a valid or verified contract, the state agents are trespassing upon our estate and infringes, abridges, and abrogates our fundamental rights and freedoms as secured and guaranteed by the Jamaica Constitution as amended 2011 by assent. Number three, this is a reason for our do not trespass notice issued to the public service authority agents upon first contact in the public arena. The law of contract governs. This is why my do not notice contract I gotta stand predominant in all of this. Yeah, man, literally stand predominant in all of this. Anyway, this should be short and sweet. I really don't know what go on with me sharing of the information. I'm not sure what go on, but me just drop that information here and say, boy, me and the state agent, the government state agent, the government of Jamaica, me and them not have no contract where we can discuss. None at all. You understand? Yeah, man. And right now, any discussion we're gonna have, I point out all of the default and the fraud where them bring forward, and me gonna need my automobile returned to me in a pristine condition like how them take it from me. You can't tell me come pick up my car and me can't put my key in my car and drive out. I won't accept the bullshit like last time when me have to go spend how much money, me have to go cut brand new key because of the loss, and I will not accept that. You understand? And by your guys' own actions or inaction, by your guys' commission or omission, this is how we not go judge. Me a tell you say me now come back on the court and me a dare you for sending the police on my location, and I have my location. But they are 2 East Greater Portmore, 2322 East Greater Portmore. Anytime me I come a court and if I come bring car and carry me go there and make sure the car carry me back home. This is how me I go deal with it. You not pay me for waste my time. You understand? And when me I come in a court, if you can't present a contract where you deal with, where we have I go discuss, me I sending you up and down the mother brawling inside of that court. Literally. If you not have a contract I discuss, now mess with me. Right now, you owe me, and it's incumbent on you to do the right thing. But you already violate a no trespass notice, and by doing so, you initiate the estate fee schedule. And I've told you that for over a year, me I say, what not deal with. So we just bring information for bring clarity. The brave may fall, but will never yield under no circumstance, not when we stand up with truth. Dave D. Kelly, court clerk, Spanish Town court clerk, D. Kelly, that risk management game where you play, you fail. You understand? You cannot underwrite my bond car. You're fired. You can't represent me under no circumstance. Pussy. I want to tell you some whole heap of thing, but you want the information go. I don't want them just lick it wet. Fire burn. This is how we bring our truth. Yeah, man, on our perpetrate fraud, man. On the very first stop, the very first instant, interfering with my liberty without constitutional delegation of authority. That means on our outlaw, on our break the law. When he's outside the law, right there. And when you have a oath or affirmation to uphold the constitutional laws and to serve the people of Jamaica, want to go against that is another violation. However, none of that not mean nothing. What is most important is the do not trespass, breach that violation, because that contract is active. This is what is extant. Because we are talking about contract law, and the law of contract governs. So I want to see the police, these 2 police officers, because the 3rd police officer Porter is a decent gentleman. I can't get this man involved in this, because I show him the documentation, him acknowledge it, and him stand away from it. But the unlearned, John's senior sergeant of police, I don't know if him drink, but him look like he was drunk out there. You understand? And then him carry this young constable, Andel Morgan. Well, Andel Morgan said him no know, him no mind participate. So he shall be held liable and accountable also. if we not publish with information, nobody will know it. You understand? And them kind of information, yeah, shall be suppressed. The views are going to be 10, 20 if it reach 30. However, the information, priceless. Priceless. Rebut it. You think the judge can tell me, say, hey, this is incorrect when we are demonstrate law? Your opinion, judge, mean jack. This is why an untidy judge could have come out and talk about illegal, unlawfully evidence. Oh God, illegal evidence obtained in Jamaica is admissible. And when you got the Privy Council, them say, oh, no, that don't work right here. So who you guys are going to believe? These judges who are unlearned, unknown absolutely nothing, or you're going to follow the law as it is written? We choose to follow the law. Yeah, man, I'm born on a public policy. Yeah. Born on a federal slavery. Yeah. And that is it. Again, the brave may fall, but never yield. And we say bold and brave, firm and strong. Give thanks, free people.